Thank you so much, Tyrell. And with us in studio, once again, we do, of course, have André Styger. And we have, once again, another special edition for Let's Talk Legal, made possible by Neumann van Rooyen attorneys. André, thank you again so much for joining us in studio.
Jessica, thank you for having me. Always a pleasure to be visiting you.
Absolutely. Now, today you're actually here to chat more about a new act called the Property Practitioners Act that is coming into effect. Now, obviously, a lot of people are, talking about this. What is all the fuss about?
Well, the Act is going to have some profound impact on people that wants to either buy or sell a house after the 1st of February or rent or lease a property. So if you're one of those people, you might want to take note of the implications of the Act because it is coming into effect, as I said, the 1st of February. And it's replacing the old Estate Agency Affairs Act that was promulgated in 1976. So it's about time for an update. And what is so nice about this Act, it is consumer driven, so it has the public in mind, and it regulates the property industry as far as it relates to agents, bond originators, valuers, attorneys, and all of that in lieu of protecting the public or the consumer out there against malpractices. So a very interesting act with some very handy implications for the man on the street or the ordinary person.
So now, how will it influence, just your ordinary person?
Well, I think there's a couple of things, but let me start maybe with the most important one. The Act brings into effect what they call a mandatory disclosure form. So from the 1st of February, if an estate agent wants to lease a property, or if you want an estate agent to sell your property and you go to them and you give them a mandate and say, listen, find me a tenant or find me a purchaser, they are compelled by the Act to have a mandatory disclosure form, which is basically, people call it a snag list. So there's a prescribed form that the seller or the landlord will have to complete to say, listen, these are the faults in the property, and there's certain things that they have to got it clear from the roof, past, the geyser, the whole stuff. It's all in the Act there. And it says, it goes as far to say that an estate agent is not allowed to take a mandate to either find a tenant or a purchaser unless the mandate includes this mandatory disclosure form. So that's one thing. So for the landlords or for the sellers, they will see that all of a sudden, they've got to make this disclosure form. Obviously, it goes a bit further. Then it says then when any prospective tenant or purchaser wants to go and look at a property either to buy it or to rent it, that disclosure form must be made available so that they can see exactly what has been declared, the snags and the faults on the property, and take that into account when they start negotiating prices or when they want to sign an agreement. Then another impact the Act will have is as far as regulating the industry is concerned, is that it will protect the consumer by regulating estate agents, bond originators and so forth that are not properly qualified. So let's say they're a candidate estate agent, which will now in future be called a property practitioner, somebody that's still in training or somebody that is going through the process of being registered or being qualified, then that person must declare his status, and he can only work with the public under the supervision of a properly qualified property practitioner. If he fails to do so, the landlord or the seller or whoever is paying the commission can actually refuse to pay that commission, and if they have paid it, they can claim it back from the estate agent or the property practitioners. Not only estate agents, just keep that in mind. It refers to bond originators, valuers, even some impact for the attorneys, which is basically the next one I think that is worth taking note of, which says that an attorney from now on, from the 1st of February, will not be allowed to pay any commission or monies over to a property practitioner. For today's purpose, I'll just talk about estate agents, unless they have on file a certified copy of that estate agent's fidelity fund certificate, which basically serves as proof that this person is properly qualified, covered by the Property Practitioners Regulation Authority, so he's entitled to do business. So what they've done effectively is made the attorneys attorneys, the gatekeepers or the supervisory body, and that in the process what they're aiming for is to eliminate unscrupulous practices, a lot of people giving themselves out as agents or property practitioners, and in the process, hurting the public out there. So if there's a sale or a rental agreement and there's an attorney involved, that attorney will have to get a copy of that certificate before he is allowed to pay over the commission. Should he proceed doing so, he does it at his own peril. Not only can the client, let's say the seller or the landlord, claim back the commission from the estate agent, but he will actually effectively have a second bite at the apple to claim that commission back from the lawyer that was involved in doing the property transaction because of professional negligence and not following the law and getting these certificates before the payments were made. So you've got a double barrel protection for the public, where the lawyers need to check and the estate agents need to check. And I think this is a well-intended and a very welcome piece of legislation.
Absolutely. Now, André, I think this is so much, to take into consideration. So from the 1st of February, what do we have to look out for?
I think just to make it simple, if from the 1st of February, if you're selling a house, buying a house, or renting or leasing, or you're dealing with a bond originator or a valuator, make sure the person is properly qualified and has the paperwork to prove it, because that will be some kind of insurance. Once you have a claim, you can claim against the Fidelity Fund. So ask the person that's you're dealing with, are you properly qualified, and please provide me with the proof. And then ask them for the proof of the Fidelity Fund certificate. The law goes as far to say that the property practitioner must display this certificate on a prominent place everywhere where they do business. So it's not a matter of getting it out of a file, it should actually be against the wall. If you have those two things in place, then obviously you are covered to a certain degree, and then brace yourself either for completing a comprehensive disclosure form where you have to tell prospective tenants and buyers what's fault with your property, or if you're a buyer or a tenant, then at least call on that form and say, listen, I'd like to know exactly what did the seller or the landlord disclose, because if before I enter into an agreement, I'd like to have a full disclosure, which is an excellent thing to call for. So call on that, insist on that, you're entitled to it, and it will be law from the 1st of February.
Wow, André, I think, you've really shed some light in this segment as well. So thank you so much for joining us in studio, and it's always a pleasure having you.
Thank you for having me.
And there you have it. That was, of course, André Styger from Neumann van Rooyen Attorneys, and of course they are the proud sponsor of Let's Talk Legal. Thank you, Tyrell. Back to you in Studio 3.